Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome, good evening, and Juma Mubarak from the Legal Ease team. This is Legal Ease, the show that converts legal jargon into legal ease. As we've always promised you and as we've always done, inshallah, we hope that we've always done, we've tried to bring you the most informative and most educational viewing this side of the Southern Hemisphere. Tonight will be no different, inshallah, as we look at two groundbreaking incidents where South Africans were involved, Rafa and the Mavi Marmara, history in the making. To do this with us tonight, we have an international human rights expert in law and soon to be one of the international human rights heavyweights, Mr. Ziyad Patel from Ziyad Patel Attorneys and a member of the Muslim Lawyers Association. And to be honest, a humanitarian and activist at heart. So let's say assalamu alaikum and welcome now to Ziyad Patel. Mr. Patel, jazakallah for joining us. Assalamu alaikum.
Wa alaikum assalam. Thank you, Nadeem, for having me on your show.
It's a pleasure and thank you for honoring us, really speaking. Looking at the stuff that you've done around the world, in Istanbul, around the world, in Africa, what you've done in Egypt, at least what you've done for the Egyptians, your struggle in respect of the Gazans. You really have been exemplary, and inshallah, attorneys who have the power of office like you do should really utilize these powers in the correct way. And inshallah, we can all strive to be like you. So guide us in that regard, Mr. Patel. Ziyad, what we're discussing tonight, as you very well know, Rafa and the Mavi Marmara, two things which you have some knowledge about, and that's being that's understating it, so to speak. But before we get there, just a little bit of background on you. Ziyad Patel, Ziyad Patel Attorneys, what it is you do, how did you become interested in international human rights? Remember that we're talking to lay people, so people who don't really understand much about the law, and this is why hopefully they watch the shows, inshallah. So, over to you.
Thank you, Nadeem. Thank you so much for this gracious invitation and welcome on your show. It's very plain and simple. I don't look at myself as a high expert in any sort of field. I approach it with a reasonable mindset of understanding what the rules and the regulations are. My involvement started predominantly in 2009 when I joined the Muslim Lawyers Association, particularly on the gross violations that occurred in the Gaza Strip during Operation Cast Lead. That was the initial phase of us considering some type of lawfare, and it was the inception or the birth of what we call today the Gaza docket. From the Gaza docket, we had some very learned and intuitive legal professionals such as Advocate Feroz Boda, who brought attention to the Rome Statute, which South Africa had become a signatory to in 2002. Subsequent to that, South Africa had implemented the Rome Statute, which we have the domestic act called the International Criminal Court Act. And that is the piece of enabling legislation in South Africa that we utilized in, number one, bringing a complaint against the Israeli armed forces and the Zionist, the Zionist regime at the time. After Operation Cast Lead, as you may be well aware, Nadeem, that was a catastrophic war that was committed against Palestinians. There's so much to say about that particular war, also looking at collective punishment, the forms of munitions that were utilized. We had teams that had traveled to, in fact, Egypt just after the war, when they had allowed very, very injured civilians from Gaza that entered Egyptian hospitals, and there was then evidence that was taken from these injured Palestinians and so forth. And that comprised what we call the Gaza docket. We had a team of lawyers from the Muslim Lawyers Association that worked days and nights to ensure that a proper complaint was lodged before South African authorities, namely the South African Police Services, a specialized unit, as well as the National Director of Public Prosecutions, a specialized unit there.
Okay. So, Ziyad, we're looking now at two specific things, one of which you were very actively involved in, that being the Mavi Marmara, which was the flotilla which floated towards Istanbul, and then essentially an incident which occurred where certain quote-unquote IDF members or military essentially opened fire on a boat of humanitarian aid workers. And there was obviously serious injuries and deaths in that. And that was something you were very much involved in. And we're going to essentially discuss that at length in the second part of the show. The first part of the show, essentially, we're dealing with Rafah, the Rafah border, the opening of the Rafah border. And this is an application which was made by the PSA, which is the Palestinian Solidarity Alliance. And this application was essentially made to the African Human on Human and People's Rights, African Union, sorry, on Human and People's Rights, I apologize, and saying to them, we request urgent emergency relief. What do you know of that application?
Absolutely, Nadeem. And I would like to commend the legal team that was involved. And I'm aware, Nadeem, that you're the attorney of record, particularly on this matter. And the amount of time and work that goes into preparing this type of complaint and to have achieved this type of result, alhamdulillah, that there has been a positive step in the right direction. Most certainly, and I was trying to draw correlations between how the Zionist regime operates and the regime, or this Egyptian regime, and I see so much of similarity between the two. The continuous blockade of Gaza, and in time of this particular war, Operation Protective Edge, which happened between June and August of last year. I remember we also had arranged a meeting with the National Director of Public Prosecutions, which Nadeem, you attended with me.
Correct, yes.
When we informed South African-based local authorities of the status of the current war, that affliction that was going on during Operation Protective Edge. Most certainly that was heartbreaking to not have the Rafah border crossing open, to allow essential humanitarian aid into the Gaza Strip, whilst these Israeli forces were basically destroying the entire place. We had essential humanitarian aid that needed to enter Gaza, and more importantly, Nadeem, we had civilians enclosed in the Gaza Strip. The borders between the Gaza Strip and Israel were definitely closed, and at least they should have allowed civilians to cross over or seek asylum into Egypt. And for that not to have happened was condemnable and unconscionable. And most certainly it was again the lawyers utilizing the instruments of lawfare, and in this particular instance looking at the rules pertaining to the African Commission on Human and People's Rights for the availability of requesting. I think it's in terms of Rule 79, the decision on matters of emergency, where this application, I'm aware, was brought, and it basically, it states that the Commission shall treat a situation as a matter of emergency under Article 58, subsection 3 of the African Charter, when it is one of serious or massive human rights violations.
Let me stop you there quickly, Ziyad. So you see, and here's where and it's got a bit of a curveball, and I apologize in advance for it, but let me just throw this curveball. And remember, whilst I wear a hat as an attorney, and of course I'm a Muslim at all times, and that hat never leaves my head, remember also that we have people on the other side who are watching the show who are not attorneys. Yeah. So they're sitting there, and their question in their mind is, hang on a second, guys, this is a war. We're engaged in a war. You're talking about due process. You're wanting to follow due process when due process is not being followed by those very entities that you're intending on enforcing this process on. What do we do in a situation like this? How far do you think a process like this can continue, whether successful or unsuccessful? And we're going to deal with this because this is because I think in a sense we answer that question on this show tonight. We answer that very question. We see that there's been a result, but in your understanding, we're talking about the African Union. We're talking about a complaint which was lodged in August of 2014 in the midst of the war. We're asking Rule 98. We're saying we need emergency relief. Okay? We need an interim provision for emergency relief. What does the Act say in respect of emergency relief? The Act says simply that in the event when the country to whom an application is made in its own discretion feels that there is a requirement or serious or massive human rights violation to provide emergency relief, they can deal with it on an emergency basis. We're talking August 2014. Let's quickly look, Ziyad, at the complaint that was lodged with the African Union. It's coming up on the screen now, and we'll give the viewers a little bit of insight, understanding as to what it was that the lawyers actually did. So, Ziyad, looking here, it's Communication 479 of 14. It's the Palestinian Solidarity Alliance, PSA, and 5 others versus Egypt. So the 5 others were the ICFR, the Human Rights UK, and 3 others. And essentially, it was versus Egypt. So let's just look at this. African Union, why does the African Union have jurisdiction in this very instant?
Nadeem, the issue of jurisdiction comes back to the rules that needs to be looked at.
Yes.
And particularly, I mean, in this instance, if you look at Egypt and the situation, geographical location of Egypt and the signatory of Egypt to a particular African charter would provide an issue of jurisdiction on hearing this type of matter.
Right.
We also have to, take into cognizance that South Africa is also a possible signatory to the African Charter in Africa.
Right.
The issue, what needs to, we need to break this assumptions down, and most certainly the decision by the Commission is too late. One of the decisions that was made is that they will not hear the complainants on provisional measures. The issue around provisional measures is looked at where the complainants have sought provisional measures and final relief.
Right.
And what was the provisional measures and the final relief? It related to essentially allowing essential humanitarian aid to get into the Gaza Strip at the time of the war. As you just mentioned previously, we were in the midst of a war, heavy weaponry, an organized Zionist military regime.
Yes.
Imposing
ducks, really.
against civilians.
Yeah.
And most certainly, I'm a firm believer of resistance and self-determination. And in this instance of affliction and people's properties being destroyed, most certainly Palestinians and had a right of resisting the type of occupation and aggression that was being committed by the Israeli military. However, Nadeem, just to make reference to that, is we must remember that whether we look at the African Charter of Human Rights or whether we also look at, for instance, international law or international humanitarian aid law, all these laws and conventions speak about, in the time of war, the allowance of countries and states to have civilians leave that area of conflict. And particularly in this instance, children, women, the infirm should all have been allowed. Palestinian civilians should have been allowed entry into the Gaza, into Egypt, beg your pardon, into Egypt. So yes, the decision is a bit late in terms of the provisional measures not being granted because there needs to be a view of the final relief that is sought.
Right.
The status of the Rafah border at the moment is still very controlled. It allows sometimes entry into Gaza, sometimes it does not allow. It's extremely controlled, and it's not allowing the essentials to get into the Gaza Strip. So this is interesting in terms of taking the next step, which I think the attorneys of record need to now go and they need to now advise what you call a communication admissibility in terms of the rules to go and give evidence, to the Commission as to why the communication admissibility should be allowed. Yeah.
We're going to get a bit of a history lesson just now from the complainants themselves. We're expecting a phone call from the complainants, the members of the Palestinian Solidarity Alliance. Will educate us a little bit and the viewers and exactly how this thing came about. What is the history of the Rafah border? Whenever we talk of Israel, well, at least it certainly seems that when we talk of Israel, we can almost also usher the word Egypt. It's almost as though one cannot be said without the other in recent times. And this is a scary thing. We're going to be looking at, God willing, inshallah, we're going to be looking at the history. We're talking about the 1979 Egypt-Israel peace treaty, when essentially Israel and Egypt decided, well, Israel will now control this section of the border, the Rafah border, the main border crossing between Gaza and Egypt. And the brothers from the PSA will educate us on that. But as a lawyer, going back to my question on due process. So a complaint is lodged, right? The second document that comes up on our screen essentially is a document which shows, very importantly, and acknowledges that they have received the complaint.
Yes.
All right, so let's look at this document that's coming up on the screen shortly. And it says, the Secretariat of the African Commission on Human and People's Rights received a complaint on 11 August 2014 from the PSA and International Coalition of Freedom, that's the ICFR, and 4 others, and submitted against the Arab Republic of Egypt. Right? So it says this. So they acknowledge that they've got this. And then it goes on to say what the complaint is about. It summarizes the complaint to an extent, and then also continues a little bit later to say what now they are intending on doing. Due process.
Yeah.
Ziyad, talk to me now. You were just saying about too little, too late. They've received the complaint. It's there.
I think that is the first success step, and why this is a big decision.
Yes, tell me.
Is that there's acknowledgement of this complaint. The African Commission on People and Human Rights are not saying that they do not have jurisdiction to hear over the matter. That is essentially a major step in the right direction, because it opens up now the opportunity for the complainant's attorneys, for the complainants, to prepare the admissibility evidence that needs to be provided at the Commission. And I think it will be in about 2 months' time. There's a process that needs to be followed, which we can talk about a bit later, because that admissibility evidence then has to be submitted to the state party that is afflicted in this issue. In this instance, the state of Egypt will then have an appropriate time to respond on it, and from thereafter, the processes of the rules will need to follow. So I think essentially, at least the African Commission is now taking cognizance of this matter. They should have acted much earlier, at the time in the midst of the war itself. And I think this is the observation as an attorney involved in this area of work, that the legal processes always follow later. And we don't get the urgent and the interim relief that was sought. Particularly, Nadeem, we did mention that due to the humanitarian crisis and the emergency that was, situation that the Palestinians found themselves in Gaza, that this application was brought on an urgent basis in terms of Rule 79 of the Commission, Commission's rules. And what had happened was they did not act on it, the decision on matters of emergency. And I think it states, it presents the danger of irreparable harm, requires urgent attention to avoid irreparable damage. And in this instance, civilians in the Gaza Strip have suffered. I'm sorry to say it, but they've suffered irreparable harm. And, civilians that could have left, gone through the Rafah crossing into Egypt, were not allowed that opportunity. Nadeem, you also have to look at the geopolitics and as you said, the treaty between Egypt and Israel in 1979. The geopolitics, I see so much of similarity. For instance, the Egyptian regime. So
can I stop you there just very quickly? I think we've got one of the brothers on the line with regards to the complaint. Just give me a second. I think we've got a bit of a. Okay, that looks like he's dropped. Let's wait for them to get him back online. Sorry, carry on.
Yes. So as I was saying, the similarity between the two regimes. And Egypt's counter argument for keeping the Rafah border crossing closed is the issue of the 30 plus minus 30 military personnel that were supposedly attacked by Palestinian militants, and they're using that as a justification. However, we need to understand proportionality and collective punishment. Where do these principles fall into place? Protective edge, for instance, was an issue around a possible single Palestinian person who was involved in a fracas, and there was a killing of an Israeli civilian. And where is the proportionality of the Zionist regime's attack on the Palestinians? And we're looking at it again, it's collective punishment. Egyptians, for instance, the Egyptian regime, same situation. There's no justification. And our law, particularly in our Constitutional Court judgment, it talks about proportionality, consideration of factors, of a crime of crimes that are committed and the factors that need to be looked at. Proportionality is extremely important. We see it in Operation Cast-Lead, we see it in Operation Protective Edge. All these operations by the Zionist regime lacks proportionality. Yet, they want to talk about democracy and constitutionality and human rights. So clearly, reports, significant reports by the Palestinian Center for Human Rights, also locally based, academics, for instance, that wrote Why Israel.
Yes.
Feroz Osman and Soraya Dadu from the Media Review Network have explained in detail, the issue of why Israel remains an apartheid state. It goes further than that. Israel is an apartheid state. It practices colonialism, and it also
we're
is a
looking at now
occupier.
Israel Apartheid Week, which is something that's been done by the Give me a second, Ziyad, let's just see if we've got the caller back online. Okay, all right. I think it looks like we've got a bit of a communication problem. But being that as it may, Ziyad, we're heading towards a commercial break in just a few seconds. While we do that and hopefully get the caller back online, inshallah, we'll sort out that communication area and we'll discuss this, because I think it's very important for people to understand the history of this thing. Where is the Rafah? Yes, we've said it's a 12-kilometer piece of a stretch of land between Gaza and Egypt, which essentially is the border crossing between the two, one of the main border crossings. And this is closed. As we said, you're looking at mice in a steel trap who can't get out. And that's really the scary and the reality of what we're talking about, and the reason why an application of this nature, as you rightfully said, was essentially made. Ziyad, looks like we're going to be going to a commercial break, and when we come back, inshallah, we'll be talking still to Ziyad Patel and hopefully have the brothers from the Palestinian Solidarity Alliance, part of the complainants of this complaint to the African Union against Egypt for the opening of the Rafah border. Assalamu alaikum, stay with us. This is Legalese. Assalamu alaikum rahmatullah. Welcome back to Legal Ease, the show that converts legal jargon into legal ease. If you just joined us, we are talking to Ziyad Patel from Ziyad E. Patel Attorneys, an international human rights expert in law and someone who has a lot of experience, both locally and abroad, with groundbreaking and historical matters such as the Rafah border as well as the Mavi Marmara, which we'll get into in just a few minutes. Before the break, we were talking about political issues surrounding something like the opening of the Rafah and an application or a complaint to the African Union in respect of the opening of the Rafah border. And inshallah, soon we'll be hearing from the Palestinian Solidarity Alliance, the complainants in the matter, as to exactly what this is about, why and where the Rafah border. Whilst we're waiting for them to come on, Ziyad, just take me back to this feet-dragging exercise. You mentioned earlier that there's a lot of political play in something like this. We looked at the correspondence where we show the complaint was made. We also saw document correspondence from the African Union to the Attorney of Record saying, hey, we've got your complaint, we understand it, we've summarized it, we've done the work. It's not like it's been swept under the carpet. We acknowledge it. Okay? This happens between the months of August and somewhere around about December. The war has ended. Irreparable harm has occurred. The rules talk about massive and serious human rights violations in an effort to prevent these things.
Absolutely.
Why the delay?
Absolutely, Nadeem. Nadeem, I'm picking this up not only on this issue of the African Commission on People and Human Rights. I'm picking up this situation also when you look at how the ICC drags its feet. I'm picking up the same situation when you look at our South African-based authorities, the South African Police Services and the National Director of Public Prosecutions. And it comes back, to issues of political will, number one. Do these authorities, are they being influenced, although they need to be independent of the executive decision-making process? But is there an undue influence and a lack of political will? For instance, we found that to be a situation seriously in South Africa when we saw the local authorities dragging its feet on the Gaza docket. There were a number of other dockets that
but there again, there were some groundbreaking outcomes that came out of it, and more importantly, something that added substantial direction to a complaint to, for example, the Gaza docket, to the issue on Operation Cast Lead. What came out of that? And we'll talk about that when we look at the Mavi Marmara, because it really is that really surrounds that issue. Before we get there, let's finish up on the Rafa board, and let's talk a little bit more on this issue. I don't know if we're going to be getting the gentleman from the PSA yet, and it looks like we are going to be running out of time. We need to deal, obviously, with the Mavi Marmara. But being that as it may, let's look at the third slide. So I was talking to you about due process. You know, due process really encompasses law. It encompasses legal. It talks about you follow the process, you follow the rules, you follow the articles, you follow the act and the sections. Something must happen. And that's something that you've really, that's something that you've done.
Absolutely, Nadeem. The African Commission has dragged its feet on this matter. There's no two ways about it. Just looking at the time period that was involved. I always state when, requested to speak at different gatherings and so on and that sort, that the legal, the enabling legislation, the regulatory framework, the conventions that we utilize to bring this nature of complaint, it's a specialized complaint that was brought by your office, Nadeem. And to comply with the legal requirements to ensure that the African Commission will exercise jurisdiction over this complaint, and to acknowledge, as you indicated, that they've acknowledged this complaint and they're requesting from the complainant's attorneys to provide the communication admissibility that needs to happen in about 2 months' time, is an acknowledgement. But the issue is even the urgent and interim relief that was sought. It's clear that these tribunals, these commissions are not equipped enough to deal with immediate situations. Right. And,
equipped
my hunch...
Or have the will. You've talked of political will, and these are two very different things.
No, absolutely. I think it's two issues here, Nadeem. I think it's the being able to be adequately equipped in order to have the instruments in place, the enabling environment in order to deal with this nature of complaint at the time when the war was happening, and also the political will.
Let me stop you very quickly. Sure. We've got Brother Ibrahim on the line. Let's listen to Brother Ibrahim. Assalamu alaikum, Ibrahim. You may go ahead. Assalamu alaikum, Ibrahim. If you can hear us, you can go ahead. Ibrahim, if you're there, you can go ahead. Okay. I'm not sure. It looks like they're trying desperately to sort that out, but inshallah, make dua, it'll get sorted out. Inshallah. So you're talking about these two issues, and I concur with you. These two issues. So one, that of inadequacy, but when you are tasked with such a huge responsibility, like preventing, on your own words, we don't draft the charter or the rules, we just abide by them. On your own words, preventing massive, the words are clear, Ziyad, we can read them again. Yes. Massive and serious human rights violations. We're not making this up, right?
True.
What then? If you are tasked with this but cannot deal with it, one might ask, when is enough enough?
And I think this is the issue of state bodies that are parties to these, to these conventions, to put and apply more pressure to ensure that these bodies function at optimal level, are adequately enough, personnel are trained, they are legally trained minds to adequately, deal with these complaints. When I was reading through the papers, I picked up, the commission needed to sit on this. It was, even though it was an interim or urgent relief that was sought, the commission needed to sit. They needed to have a plenary meeting, and to get heads of state or. And
one asked the question.
Absolutely.
I mean, if you want to ask the question, if you're talking of emergency interim relief, why then do you require a formal sitting?
A formal sitting,
You've got the secretariat. Let's look at the third slide in that segment of slides, Ziyad. It's essentially now where the penny drops. In February of 2015. The African Commission writes to the Attorney of Record, and this is what they say. They say, subject communication 479 of 14, which is essentially the reference number, PSA, Palestinian Solidarity License, 5 others, versus Egypt. And it says, I write to inform you that the African Commission on Human and People's Rights, during the 17th extraordinary session held from 19 to 28 February 2015 in Banjul, Gambia, considered your complaint and decided to be seized of it. Further, the Commission considered your request for provisional measures. Now let's just dissect this somewhat. We're talking provisional measures in February the 2015.
Doesn't make sense, Nadeem.
Doesn't make sense, yeah?
Yeah, it doesn't.
Let's go further. And it says, and decided not to grant it. Well, you decided not to grant it in February of 2015 because there was no need for it in February of 2015. But they go further and they say, right, the Commission's decision on seizure and provisional measures is herewith attached. And it then attaches its reasons therefore. Okay, it goes further. Please note the communication has been registered in reference and utilizes as your reference. But then it goes and says, in accordance with Rule 105 of the Rules of Procedure of the Commission, you are required to present evidence and arguments on the admissibility of the communication within 2 months of this notification. So if we look at the rules relating to Rule 105 of the rules of the Commission, very quickly, which we have in front of us. Okay, there we go. All right. So ultimately it says, when the Commission has decided to be seized of a communication pursuant to the present rules, it shall promptly transmit a copy of the complaint to the respondent state. It shall simultaneously inform the complainant of the decision. Oh, sorry, I'm being cut off. We've got the caller back online. Okay. Apologies, Ziyad. Let's take the caller. Assalamu alaikum. Good evening. Assalamu alaikum. Can you hear us? Assalamu alaikum, can you hear us? Looks like there's technical issues. Yeah,
hello.
There we go. We've got the caller. Assalamu alaikum, Brother Ibrahim. Okay, call dropped again. Look, let's hang that. I don't think we're going to come right on that, unfortunately, this evening. We're talking about the rules. Now, you see, and this is where we've got an issue. It says it shall simultaneously inform the complainant of the decision on seizure and request the complainant to present evidence and arguments on admissibility within 2 months.
That's right.
How long has it been?
Yeah.
We're talking March 2015. So whilst we, as the legal representatives and the senior counsel and the junior counsel that will be arguing this matter in front of the Commission, inshallah, we're ecstatic. The PSA are happy. Why are we happy? Well, we're saying that a regulatory body is prepared to take cognizance of this complaint. But isn't that their job?
Absolutely, Nadeem. It is their job. And
hello.
There we go. We've got the call online. Assalamu alaikum, Uncle Ibrahim. Uncle Ibrahim, can you hear me? Looks like a technical issue. We're not able to hear him at all, unfortunately. Okay.
Yes,
you're saying.
So what's happening is we've got policy converted into legislation and conventions and rules, and the issue is about the implementation. I think, Nadeem, and that's where it comes down to it. I've picked it up, which we'll discuss at a later stage. The same situation. We had this fancy ratification of the Rome Statute, but I was told by organs of state that they are not equipped enough to be able to deal with these types of measures. So it's a particular situation that we find ourselves. Also, we talk about the rule of law and the following of due process. Alhamdulillah, there is something in place that we have a body called the African Union, and we have the African Commission for Human Rights and so forth. But it's it's going to be our duties as citizens to inform our governments, to take the advocacy route, and to demand that these tribunals and forums, carry out the justice process that it has been empowered to do so. Okay. That is extremely, extremely important. Just to come back to your Rule 105, yes, if I'm not mistaken, yes, it's Rule 105, submissions or observations. My understanding is that the complainant's legal team now needs to provide admissibility of evidence of the communications. Yes. It needs to be a formal hearing, and arguments need to be given at that convening session. Thereafter, the state, the accused state, in this instance, the state of Egypt, will have an appropriate time to respond. Right. And you see the due process now coming out of that. Right. I think, Nadeem, it's an important decision that has been made, particularly because this commission has said that it is now seized with the matter.
Absolutely. There's now an obligation upon itself.
There's an obligation, absolutely, yes. There's an obligation on this commission. It becomes part of our documentary record of the Egyptian regime's actions in this instance of closing the Rafah border and not allowing the essential aid to come through and allowing refugees to enter into Egypt.
Absolutely.
You know, so
let's hear. Brother,
okay.
I apologize. This should be the last time. If we don't get it right, we're not going to try it again, inshallah. Assalamu alaikum. Good evening, caller. Caller, assalamu alaikum. Good evening. Assalamu alaikum. Can you hear me? Yeah. All right. Unfortunately, let's leave that there. Jazakallah for your attempts, brothers, for trying to call in. Unfortunately, as the complainants, the PSA would have been very valuable to have you speaking on the show. But inshallah, we'll have other opportunities, and Almighty knows best in these regards. Look, to wrap up, Rafa, very quickly, Ziyad. You know, we're talking about doing whatever we can. We're talking about following due process, which we as lawyers and lawmen and women, and there's been a very influential woman in this picture, as you very well know, Advocate Shibna Mayat, and I can tell you that without her, really speaking, none of this even becomes possible. There's obviously counterparts in the US, counterparts in the UK, counterparts in Brussels, who are very influential in this application, this complaint, and really all of whom want to see justice being served. Whether that justice is going to be warm and tasty or cold and hard by the time it's served, you know, Almighty knows best. But, you know, let's leave that there at this moment in time. And let's look, Ziyad, at another issue, another case where history has been made. And that is the very case of one of our own, Khadija Davids, your client, if I may say it as that, and the issue of the Mavi Marmara. Talk to us about that.
Yes. Nadeem, there's so much to talk about the Mavi Marmara, but, you know, to inform your viewers about where, you know, the status of the case. The Mavi Marmara was a single ship that was part of a flotilla that had left from ports to enter the Gaza Strip. Right. You know, humanitarian aid was their goal. A few nautical miles off the high seas.
And just to stop you, this was all legitimate? It has had the relevant consent and approval from government?
Absolutely,
right.
Absolutely.
Important to mention, I think.
Yes.
Having
all
regard
consents,
to the
all approvals. In fact, there was also evidence, you know, when the aid was being packed onto the cargo, or the cargo was being packed onto the ships, right, that there was video footage to indicate that there was no weapons being put on.
Okay.
And it was purely aid. Right. You know, and to basically end the siege and the blockade after this terrible onslaught that occurred during Operation Cast Lead. Gaza was reeking of, you know, of the situation. It needed humanitarian aid. It needed supplies and materials to rebuild.
Of course.
And what had occurred was, you know, you had the Israeli Navy, you know, in the high seas, diverting, basically hijacking, pirating these ships, this flotilla of a number of ships, which was about 7 ships in total. The Mavi Marmara had about 550 passengers aboard, redirected and taken to the port of Ashdod. There was already planned processing centers to get the passengers off the ships into detention cells, and they were then being detained. And we had in this instance Khadija Davids from Cape Town, a journalist who experienced firsthand. And
she was on the ship. She was there just reporting. Was that her role?
Yes, her duty was to report, you know, the flotilla and the events that was going to unfold. And she particularly was affected by this incident. You know, it's well documented her experience. I've indicated also in Istanbul, Khadija had also tendered evidence in an Istanbul criminal court on this issue.
So, yes.
And it was predominantly, these were gross violations of rights. We call it war crimes, crimes against humanity. And particularly South Africa once again has enabling legislation. So we got to look at, you know, the act that we looked at was the International Criminal Court Act, which South Africa ratified, and we utilized that act. The reason the authorities, and coming back to, you know, why Rafa, you know, the commission delayed on acting on it, or even, for instance, in some of our local dockets, in this instance, South African authorities could not drag their feet, particularly because the jurisdictional link was fulfilled. Khadija being a citizen and a national of South Africa.
So who put this in? Who set this in motion? Was this your office?
Yes, this was done through my office. Advocate Boda was very involved.
Right.
Predominantly, it was again Muslim lawyers from the Muslim Lawyers Association, myself, Advocate Firoz Boda, and we also consulted with Advocate Professor John Dugard to essentially get legal opinion on issues regarding gravity with the International Criminal Court.
Right.
You quite rightly mentioned a very inspirational woman, Advocate Shibna Mayet.
Right.
I had commissioned her to attend some of the hearings in Istanbul.
Right.
She did an extraordinary job. She attended the hearings, provided back opinions, memorandums, and we've basically been, keeping abreast with the developments in Istanbul, as well as informing our local authorities on this side. But I think, Nadeem, Khadija's case, we see a success in terms of the utilization of the Rome Statute and the International Criminal Court Act. However, we still need prosecution of these crimes.
But now I believe there was a sitting between today and tomorrow in Istanbul.
Yes. These sittings are continuing, and predominantly it's again to build up the documentary evidence record.
All right.
So we've got so many victims. It's unbelievable, Nadeem. I've sat in this courts and I've listened to some of the evidence and the testimony, and we all shake our heads and wonder, how is it possible that only, that 9 Turkish lives were lost, and it became 10 because one person was in a coma for, I think, over 2 years. Yes, so for 10 Turkish lives. The crimes that were committed by the Zionist regime, the Zionist Israeli Navy, were unconscionable. Basically gunshots at close range, denial of beatings. There was detentions. Sure. There was a whole lot of different types of crimes that were committed. And basically, the passengers aboard the Mavi Marmara tried to defend themselves of this aggressor with whatever means that they had at their disposal. So we were very surprised because we had so many victims testify at the Turkish Criminal Court in Istanbul.
Have you been able to single out individuals? Because from discussions with you in the past, I remember that there was always an issue with identification.
Yes. Individuals have been sought out. The process had been gone, it was a process that needed to be undertaken. Predominantly in Khadija's papers, we hold responsible the former Prime Minister of Israel, the former Minister of Israel, Defense Minister, all of the Knesset cabinet that was involved in this, in the orchestration of this incident, of this event, arranging for the diversion of the ships. So you've also got, the Israeli Defense Force personnel, commanders, and so forth. But 4 commanders were identified specifically.
By name?
Yes, by name. And in the Turkish court, it was issued. There was a decree issued.
Those warrants? For
those warrants.
Right.
Those warrants are subsequent. My understanding is that it's going through an internal Turkish process.
Right.
So it's not yet, the red alerts with the Interpol has not yet been given or confirmed. So there is an internal process that is being undertaken in Turkey.
So what is the effect, technically, of those warrants? Let's say, from an MPA point of view, let's look at local now. Because this is really where the ground break comes from, from a local point of view. Should those accused enter, and bearing in mind that South Africa is a party state to Interpol and to the ICC, should they enter South African soil, could they be arrested?
That's our aim, Nadeem. That's the objective of this complaint.
To make the world small.
Yes. And what's the possibility of one of these commanders, for instance, I've got the names here with me, coming to South Africa, but it could be a possibility or a high probability that they could come to within the territory of South Africa. Most certainly, South African Police Services, which is a specialized unit, the DIPSI unit, the Hawks unit, it's called the Directorate of Priority Crimes Investigation, as well as the National Director of Public Prosecutions. There's a specialized unit they call the Priority Crimes Litigation Unit. Are informed of these 4 Israeli commanders, and their identities and their names. There's a process that we're waiting for it to go through in Istanbul. predominantly in that because what the decision that was taken in November 2012 was, number one, that they had considered the Khadija Davids docket, and they were satisfied that an investigation should ensue. Secondly, that that jurisdictional links and jurisdictional requirements were met, and that the cooperation between South African authorities and Turkish authorities, can be going forward. There can be further cooperation between the two authorities.
Yes.
So the idea is most certainly when we get, when there's confirmation on the names of the 4 Israeli commanders are out there already. They are aware of it. And we need to now understand and be able to put the pressure on the local authorities. And I think the pressure, Nadeem, came in October 2014.
So you were going to tell me, right?
The pressure came in October 2014 because in these types of cases, like I mentioned earlier, they tend to drag their feet.
Right.
You'll indicate, you'll provide the evidence, there is the enabling framework, but you've got to continue being able to say, what are you doing next? And I think in October 2014, the South African Human Rights Litigation Center was litigating against the National Commission of Police Service, South African Police Services. And this was a phenomenal judgment delivered by our Constitutional Court, delivered by Justice Majid. And just to quickly, make reference to this judgment, Justice Majid states that South Africa's future relations will be based on our belief that human rights should be the core concern of international relations.
We actually have this slide. We can quickly pull it up and show everybody else as well what you're reading from. That's the last slide, essentially in the process of slides.
All right.
And you can continue to read from that.
Okay. And we are ready to play a role in fostering peace and prosperity in the world we share with the community of nations.
Right.
The time has come for South Africa to take up its rightful and responsible place in the community of nations. Though the delays in this process forced upon us by apartheid make it all the more difficult for us, we believe that we have the resources and the commitment that will allow us to begin to make our own positive contribution to peace, prosperity, and goodwill in the world in the very near future. And I think in the very first paragraph of this unanimous judgment by our Constitutional Court, it reaffirms South Africa's both domestic and international obligations once to actively investigate. Right. Yeah. Right. There were some issues relating to the presence of an accused in the territory of the Republic, and Nadeem, this is an issue about discussing universal jurisdiction. Very briefly for your viewers, universal jurisdiction is created. It's a customary international norm that deals or pertains with a foreign country utilizing its local criminal justice system to try or prosecute perpetrators of crimes outside of its territory. When another territory does not want to prosecute or cannot prosecute.
To assume the responsibility.
To assume that responsibility, in other words, to ensure that these types of crimes do not go unpunished or they are not acted with impunity. That is a very basis of universal jurisdiction. South Africa has ratified in terms of the Rome Statute, and we've then legislated what we call territorial and national jurisdiction. So when we look at the national status of a particular perpetrator or the citizen or the territory.
SubhanAllah, Ziyad, I must say, and unfortunately we've run out of time. Essentially for the show we've been discussing so much already, and as you can see, an hour is just not even close to enough to do justice. But we'll definitely going to be back. I think there's going to be a lot more groundbreaking outcomes from both of these two, the Rafa as well as the Mavi Marmara, which are ongoing. And we're going to be assisting people like Khadija Davids and the PSA as much as we possibly can, and with the assistance of the Almighty, to further and speed up the justice that is essentially served, inshallah. Jazakallah to all of you. We apologize again for the technical communication breakdowns in communication. We say thank you again, Jazakallah khairan, to Brother Ziyad Patel and to everybody for watching and for staying tuned, and of course to the PSA who have been really solid in their endeavors and their commitments in respect of human rights, and to everybody else who has assisted in these groundbreaking cases. Rafa and the Mavi Marmara, you've been watching Legal Ease. Jazakumullah so much. Juma Mubarak. Assalamu alaikum wa rahmatullahi wa barakatuh. Alaikum assalam.